My daughter Linda set my green steel thermos on a motel counter and said, "Dad, I cannot let your $900,000 debt swallow my family." The metal was cold beneath my hand. Then she drove away. Daniel was not my son. He was the widower of my older daughter, Rachel. He came back before the coffee went cold. I watched his truck stop beneath the motel's broken blue sign. He hurried through the rain with no coat, found me sitting beside my suitcase, and looked first at my face instead of my luggage. "Where is Linda?" Protecting her family. Daniel glanced at the thermos. My wife, Ruth, had carried it to our first refrigeration workshop for 31 years. Its green paint was worn silver around the lid. "Then I'll protect mine," he said. "Come home with me." Linda had left me 40 minutes earlier. That morning, I had invited her and Daniel separately to breakfast. I told them an old personal guarantee from my company might have returned as a $900,000 debt. If the claim was valid, I said, I might lose my house and leave nothing behind. There was no debt. That sentence matters. I had not forgotten $41 million in a bank account. I had not won a lottery and hidden the ticket. 8 years earlier, I sold Hale Commercial Cooling, paid the taxes, and knowingly transferred exactly $41 million into a professionally managed revocable family trust. I signed the funding documents. I was the sole lifetime beneficiary. I received quarterly reports and met the corporate trustee every January. The $900,000 debt was one verbal lie. I created no fake creditor, forged no notice, and asked neither Linda nor Daniel for money. I wanted to know who would still offer me a chair if they believed the inheritance had vanished. It was a test. It was also a cruel thing for a father to do. I would learn that those two facts could be true at the same time. Linda had listened until I mentioned the possibility of selling my house. Then she began asking whether the old guarantee could reach a trust, whether amendments signed before a creditor judgment would hold, and whether Daniel knew the balance. Daniel asked one question. "Where are you sleeping tonight?" Linda offered to drive me to what she called a temporary suite. The suite was room 117 at the Mill Creek Motor Lodge. At the counter, she said her husband had student loans, her daughter needed tuition, and she could not expose them to my failure. Then, she left. Daniel had called me twice while I was in her car. I did not answer. He found me by asking the cafe server which direction Linda had driven and checking the 3 motels along the highway. In his truck, he turned the heater toward me. "I have a spare bedroom," he said. "If this takes years, it takes years. You have a mortgage. So do most people with spare bedrooms. And if creditors come?" He gripped the wheel. "Then we let a lawyer tell us what is real. We do not leave you beside an ice machine." Daniel had installed fire suppression systems for 22 years. Rachel died from ovarian cancer 3 years earlier. During her last 7 months, he slept in a chair beside her bed and still arrived at my house every Sunday with groceries. He had no legal duty to keep coming after she was gone. That was what made every visit count. His small house smelled of cedar dust and Rachel's cinnamon tea. He carried my suitcase into the spare room, placed Ruth's thermos on the dresser, and began changing the sheets. "I can sell the second truck," he said. "It will not cover $900,000, but it could pay for counsel." I felt the test turn sour in my mouth. Do not sell anything. I'm not promising. I'm saying there are steps before panic. My phone rang before I could tell him the truth. The caller was Miriam Cole, a senior officer at Northbridge Trust Company. "Mr. Hale, are you alone?" I looked at Daniel. "I am with someone I trust, but he is not authorized on my accounts." "Keep it that way for now." We received an emergency care reserve request for $4.1 million. It directs payment to Hale Family Care LLC and carries what appears to be your signature. Daniel stopped pulling the sheet across the mattress. I signed no request. There is also a physician letter stating that you lack capacity to manage financial affairs. Because the documents conflict with your standing instructions, we suspended the request. A suspension protects the funds. It does not determine who created the papers or whether you are competent. Who submitted them? The delivery email identifies Linda Hale as Family Care Coordinator. I can send copies to your attorney. While Miriam stayed on the line, I called Priya Shah, my estate attorney, and hired licensed investigator Elena Ortiz. Priya told me to preserve the trust records and accuse no one without proof. Elena knew our state's recording law. The question I had asked at breakfast changed shape. This was no longer about who loved an old man without an inheritance. Someone had tried to move $4.1 million using my name and a statement about my mind. Do not release anything, I said. Nothing will move without formal review. I ended the call. Daniel stared at me. What trust? I told him the truth from the beginning. The company sale, the taxes, the $41 million, the quarterly reports, the false debt, the breakfast test. He sat on the edge of the bed. I offered to sell my truck. I know, you let me believe Rachel's father could lose his home. For less than one day. That does not make it honest. He was right, I apologized. Without explaining the apology away, Daniel stood and walked to the doorway. For several seconds, I thought he would tell me to leave. The room is still yours, he said, but do not make me audition for this family again. That was the first consequence of my lie. It would not be the last. At 9 the next morning, I met my estate attorney, Priya Shah, at her office. Miriam joined by secure video. Daniel drove me there but waited in the lobby until Priya asked whether I wanted him present. No, I said, not for the trust documents. If Linda accused him of chasing my money, I wanted a clean fact. Daniel had never seen a statement, held a password, or received account authority. Priya reviewed the suspended request. My signature appeared above a certification that I had approved a $4.1 million reserve for assisted living and medical management. Hale Family Care LLC had been formed 19 days earlier. Its manager was Linda. The physician letter carried the name of Dr. Samuel Kerr, my regular doctor. It said he had diagnosed progressive cognitive impairment 2 months earlier. I had seen Dr. Kerr 2 months earlier for a sore knee. Priya called him, with me present. He confirmed that he had never made that diagnosis. The top half of the letter resembled a routine visit summary from his office. The paragraph about incapacity was not his. You have evidence of a suspicious request, Priya said after the call. You do not yet have proof that Linda forged your signature or altered the medical letter. An email address and an LLC are not a confession. What do we do? Preserve everything. Notify the trustee's fraud department. Obtain an independent capacity evaluation. And if you want facts about whoever prepared this, hire a licensed investigator who knows the recording law. That afternoon, Elena Ortiz, a former insurance fraud investigator with a state license, met me at Priya's office. She explained her limits before she accepted $1. I cannot enter Linda's home, car, or private office. I cannot plant a device in an intimate space. I will not pretend to be a criminal partner or manufacture a conversation. Our state permits recording words spoken audibly in a public place where there is no reasonable expectation of privacy. I can also observe authorized business activity and collect public filings. If the facts move into a private setting, I stop. Then stop, I said. I want evidence that can survive daylight. Northbridge kept the transfer frozen. Priya asked its fraud team to preserve the original upload, email headers, access log, and document versions. I completed a preliminary interview with an independent geriatric psychologist selected from a court-approved list. I did it before Linda could demand one, because I did not want my own opinion of my mind to be the only opinion in the room. Daniel retained separate counsel at his own expense. He did not become my agent. He did not receive access to the trust. He did not sit in on my capacity interview. He did refill Ruth's thermos every morning. 3 days later, a document examiner found that the signature on the transfer request was an exact pixel-for-pixel match to my signature on an 8-year-old trust binder acknowledgement. A live signature does not reproduce every microscopic hesitation in the same place. A copied image does. That established the method. It did not establish who had copied it. Dr. Kerr's office found that the first page of his authentic knee visit summary had been combined with a second page created elsewhere. Metadata showed the altered file had been exported from software licensed to Mercer Document Services. Mercer was not a law firm. It was a document preparation company beside the county administration building. Elena could verify its public address and its owner, Curtis Mercer. She could not break into his computer or demand his client list. Linda called me that evening. "Dad, Daniel is frightening you," she said. "I did not tell you where I was. He took you after you disclosed a catastrophic debt. Now you suddenly think routine care papers are fraud. Did you submit a $4.1 million request? I tried to protect you from yourself. You told us you owed $900,000. A debt has nothing to do with a physician letter." Her voice hardened. "You are confused. When the court sees what Daniel has done, he will not be allowed near you or the trust." She ended the call. The next morning, Linda filed an emergency petition in probate court. She asked to be appointed my temporary guardian and financial conservator. The petition described my debt announcement as a delusion. It accused Daniel of isolating me at his home and manipulating me into rejecting essential care. Attached to it was the altered physician letter. She had moved a disputed document from a suspended private transfer into a real court case, and she had made Daniel the obstacle she needed the judge to remove. Priya read the petition twice. "This creates a real risk," she said. "The judge could impose temporary restrictions while the evidence is reviewed. Your lie about the debt gives Linda something legitimate to attack. I will tell the judge I lied. Under oath, especially under oath. Then understand the cost. A loyalty test is not proof of incapacity, but it was manipulative. Linda's lawyer will say a man who deceives his family cannot make reliable estate decisions. We answer that with facts, not outrage. I signed a sworn response. I disclosed the trust, the exact balance at funding, the non-existent debt, and every step of the test. I also disclosed the suspended transfer, the copied signature, and Dr. Kerr's denial. Priya served the evidence through proper court channels. We did not hide it for a dramatic surprise. Linda's attorney answered that I had invented the fraud claim after Daniel learned how wealthy I was. According to Linda, Hale Family Care was an innocent contingency plan, and someone at Mercer Document Services must have misunderstood her instructions. Daniel read the answer in his lawyer's office. "She says I coached you to pretend the debt was fake. The trustee has 8 years of records. Truth can be slow. That is why we keep it clean." Daniel looked at me. "Do not put my name in a new trust while this is pending." "Why?" "Because I do not want Linda punished by making me rich. I want the court to decide whether she used your name. Those are different things." It was the wisest sentence anyone spoke that week. I agreed to make no beneficiary amendment until the court had ruled on my capacity and the disputed papers. Elena spent the next 4 days doing work that looked almost boring. She downloaded public business registrations. She photographed the public entrance to Mercer Document Services. She obtained the hearing calendar and watched who entered the county building during ordinary business hours. No trackers, no planted microphones, no false emergency. On Tuesday, Curtis Mercer filed a supporting declaration in Linda's guardianship case. He claimed he had prepared forms from information supplied by the Hale family and believed every signature was authorized. That filing gave Elena a lawful reason to observe his public arrival at the administration building before a scheduled records conference. At 11:20, Linda met Curtis outside the clerk's entrance. They spoke briefly, then crossed the open atrium to a cafe. The tables sat beneath a 4-story glass ceiling. County employees, lawyers, and visitors passed within a few feet of them. Elena bought tea at the next table. She placed her licensed investigator identification and time log inside her bag. Her phone remained visible beside her cup. It recorded only speech audible where she was lawfully seated. Curtis leaned toward Linda. "The trustee rejected the care reserve," he said. "They suspended it because they want Dad live in front of them. Your petition says he has a $900,000 debt delusion." Linda gave a short laugh. "The debt cannot touch the trust. Dad funded it with $41 million 8 years ago." Curtis lowered his voice, but not enough. "The emergency papers need his signature. Use the signature from the old trust binder. It is already in the file I sent you. And the doctor's letter? Keep the real first page." The new second page makes him incompetent as of last month. Curtis looked around. If the judge orders an independent exam, this falls apart. Then we need the temporary order first. Where does the 4.1 go? Hale Family Care. Once the judge suspends him, move it before he can name Daniel. Curtis said, "You know your father did not authorize any of that." Of course he did not. Half that trust was always supposed to be mine by blood. I am taking control before a widower talks him out of it. That was the line Elena had not prompted and could not have invented. It named the amount, the copied signature, the altered letter, the false timing, the destination company, and the reason Daniel had to be removed. Elena did not confront them. She remained at the cafe until they left separately. Then she preserved the original recording, created a read-only copy, recorded its digital hash, saved her receipt, and wrote the positions of the surrounding tables and public walkways. Her attorney reviewed the capture under state law before Priya used it, when Priya played it for me. Daniel sat beside me, and Miriam joined by video as the trust's witness. Linda's voice came through the conference room speaker. Of course he did not. Daniel closed his eyes. He had buried Rachel 3 years earlier. Now her sister was calling him a widower as if grief had erased his place in the family. Miriam removed her glasses. Hale Family Care is the exact beneficiary named in the suspended instruction. I heard Ruth's thermos lid click beneath my hand. I had been twisting it without knowing. "Play it again," I said. Priya did. The second time I listened less like a father and more like the man whose signature had been stolen. "We provide the original to Linda's counsel, the court-appointed visitor, and the trustee," Priya said. "The investigator must authenticate it. Linda may challenge legality, completeness, or context. We do not edit it into a victory speech." "What about police?" Daniel asked. "The court can refer evidence, and Walter can make a report. But the criminal side will need its own review, warrants where required, and proof beyond what this guardianship hearing decides." I made a report to the Financial Crimes Unit that afternoon. The detective accepted the documents and warned me that intake was not an arrest warrant. That distinction mattered. I did not want Linda carried away because a story needed a satisfying ending. I wanted each authority to do only what it was authorized to do. The neutral psychologist completed my evaluation 2 days later. She tested memory, judgment, numerical reasoning, susceptibility to pressure, and my understanding of the trust. "Why did you tell your family about a debt that did not exist?" she asked. "Because I wanted to measure loyalty." "Was that fair?" "No." "Would you do it again?" I thought of Daniel offering his truck. "No." "Does Linda's conduct change your answer?" "It changes what I know about her." "It does not make my lie honest." Her report found that I understood my assets, the nature and consequences of my decisions, and the roles of every proposed beneficiary. It also described the debt test as calculated, emotionally harmful, and unrelated to cognitive impairment. That report did not declare me a good father. It declared me competent. Linda called Daniel the night before the hearing. He put the phone on speaker, only after telling her I was in the room. "You are destroying this family," she said. "I did not sign Dad's name. You heard 41 million and started performing. I did not know there was a trust until after I brought him home. Then walk away now. Tell the judge he belongs with me." Daniel glanced at me. "Walter belongs to himself." Linda hung up. The probate courtroom was smaller than I expected. There was no jury, no dark wood rail, and no crowd waiting for a spectacle. The judge sat above 2 counsel tables. A court-appointed visitor occupied the first row. Miriam represented the corporate trustee. Elena waited outside until called so she could authenticate her evidence without hearing everyone else's testimony. Linda sat across the aisle wearing the navy dress Ruth had bought her for Rachel's funeral. Daniel sat behind Priya, not beside the trust officer. The first question was not about money. It was whether I needed emergency protection from my own decisions. Linda testified that I had announced a catastrophic debt, rejected care, disappeared with Daniel, and then accused her of crimes. Her lawyer displayed the original trust schedule, showing that, when I created the trust, the remainder had been divided into 2 family branches. one for Linda and one for Rachel's descendants. Rachel had one daughter, Sophie, who was 19. Linda's lawyer asked, "Were you trying to steal money that was already yours?" Linda looked directly at the judge. "No. I was trying to protect Dad's estate until he recovered. The $4.1 million request came from his instructions." "Did you copy his signature from an old trust document?" "Never." "Did you instruct anyone to alter a physician letter?" "No." "Did you know his debt was fictional?" "I believed it was a delusion." Daniel later persuaded him to call it a test. On cross-examination, Priya asked whether Linda owned Hale Family Care. It was formed to pay caregivers. It had no employees, license, office, or care contracts, correct? It was new. And you were its sole manager? Temporarily. Linda did not collapse under 3 questions. She stayed calm. That made the truth harder and therefore more valuable. Then I testified. "Mr. Hale," Linda's lawyer said, "did you lie to your daughter about owing $900,000? "Yes." "You staged a financial crisis to judge your children?" I told one verbal lie. "I staged no creditor and asked for no money. But yes, I manipulated them, and it was wrong. After Daniel passed your test, you accused Linda of fraud. After Northbridge called about a transfer I did not sign, I investigated fraud. You expect the court to distinguish your deception from hers. I expect the court to examine the documents." The neutral psychologist testified next. She explained my scores and conclusion. Under Linda's lawyer's questioning, she agreed that deception could reflect poor interpersonal judgment. "Does poor interpersonal judgment equal incapacity?" Priya asked. "No, Mr. Hale understands his property, relationships, choices, and their consequences. He can revoke or amend his trust." Miriam then explained the number that would otherwise have ruined the story's logic. "Mr. Hale did not discover $41 million after 8 years, she said. "He knowingly funded the trust with $41 million in net sale proceeds. Northbridge has delivered quarterly statements since then. He is the sole lifetime beneficiary. Linda is a contingent remainder beneficiary with no present withdrawal right." Could a $900,000 business claim automatically transfer $4.1 million to Linda's company? Priya asked. "No." "Did Northbridge approve the request?" "No. We suspended it and preserved the funds." The document examiner identified the copied signature. Dr. Kerr denied writing the incapacity paragraph. Linda's attorney argued that those facts still did not prove who directed Curtis Mercer. Priya looked at the judge. "We offer the original public place recording already disclosed to all parties, together with Ms. Ortiz's authentication and preservation log." Alina entered, took the oath, and described exactly where she had sat, what she could hear, what state law permitted, and what she had not done. She had not entered a private room. She had not planted a device. She had not spoken to Linda or Curtis. Linda's lawyer objected to privacy, foundation, and completeness. After questioning Elena and reviewing the unedited file, the judge admitted it for the limited purpose of the emergency guardianship proceeding. Priya placed the speaker on the evidence table. Linda was present. Daniel, Miriam, the court visitor, and the judge were listening. I pressed play. Curtis's voice filled the courtroom first. "Your petition says he has a $900,000 debt delusion." Then Linda's answer. "The debt cannot touch the trust. Dad funded it with $41 million 8 years ago." I watched the court visitor turn toward her. The recording continued. "Use the signature from the old trust binder." Miriam's hand stopped above her notes. "Keep the real first page. The new second page makes him incompetent as of last month." Dr. Kerr looked down. Then came the $4.1 million, Hale Family Care, and the sentence about moving it before I could name Daniel. Daniel did not smile. He leaned forward with his elbows on his knees, as if the name of his dead wife's family had become too heavy to carry upright. Finally, Linda's voice said, "Of course he did not. Half that trust was always supposed to be mine by blood." The recording ended. No one spoke for several seconds. That silence was not justice. It was only the moment a mask could no longer stay in place. "Priya," asked Linda one question. "You testified under oath that you never directed anyone to copy your father's signature. Is that your voice?" Linda turned to her lawyer. He asked for a recess and advised her not to answer further while potential criminal exposure was being assessed. The judge did not treat her silence as a confession. She did not need to. She had the trust records, the copied signature, Dr. Kerr's testimony, the neutral evaluation, Elena's authenticated recording, and Linda's earlier sworn answers. After the recess, the judge ruled from the bench. She denied Linda's emergency petition for guardianship and conservatorship. She found no present basis to remove my authority over my person or property. She ordered that the disputed transfer remain blocked, prohibited destruction or alteration of related records, and directed the clerk to preserve the guardianship exhibits. She also confirmed that Northbridge could continue administering the trust under its existing safeguards, and that I retained the legal ability to amend it after independent advice. Then she referred the suspected forgery, altered medical letter, attempted transfer, and hearing testimony to the County Financial Crimes Unit and the prosecutor. Linda was not handcuffed beside the counsel table. Probate judges protect vulnerable adults and property. They do not skip a criminal investigation because a recording has played well in a courtroom. Linda left through the same public doors as the rest of us. On the courthouse steps, she stopped in front of Daniel. "You got what you wanted." He looked exhausted rather than victorious. "I wanted Rachel alive," he said. "None of this is what I wanted." I did not answer Linda. My test had helped expose her response, but it had also given her a weapon and hurt an innocent man. I could not turn that into a father's triumph. The official consequences came more slowly. Detectives obtained the original electronic files from Mercer Document Services through legal process. The upload log connected Linda's email account to the copied trust signature and the altered physician page. Business records showed that Hale Family Care's only bank account was controlled by Linda and had been opened 4 days before the transfer request. Curtis hired a lawyer and cooperated. He admitted preparing the false second page and placing the copied signature after Linda supplied both files. His account alone would have needed corroboration. The preserved metadata, email headers, bank records, and cafe recording supplied it. 6 weeks after the probate hearing, officers served a warrant and arrested Linda at Hale Family Care's rented mailbox office. The prosecutor charged her with attempted theft, forgery, use of a fraudulent medical record, and offenses related to the sworn filing. Charges were allegations, not a verdict. Linda entered an initial plea of not guilty and was released under conditions that barred her from contacting Dr. Kerr Curtis or trust employees. Months later, she accepted a negotiated plea to forgery and attempted theft. The remaining counts were resolved under that agreement. The court imposed restitution for investigative costs, supervision, community service, and a custodial sentence, whose length depended on the formal judgment and local law. I did not attend sentencing to ask for the maximum. I submitted a statement about what she had done and about what I had done. Linda was responsible for stealing my signature and trying to turn a false diagnosis into control of my life. I was responsible for treating love like something that could be measured in one morning. The $4.1 million never left Northbridge. That distinction mattered more than any punishment. The trustee's controls had prevented an attempted theft from becoming a completed one. After the probate order, I moved back into my own house. Daniel returned my suitcase but kept coming on Sundays. For a month, we did not discuss inheritance. We repaired a loose porch rail, changed the filters in my workshop, and visited Rachel's grave. When I tried to apologize again, Daniel held up one hand. "You apologized," he said. "Now be different." So I tried. I stopped creating secret examinations for people who loved me. I wrote down what help I wanted if I became ill. I signed a new health directive in front of independent witnesses. I let Sophie, my granddaughter, ask questions about the trust with her own lawyer present. I also made sure the final inheritance could be explained without mystery. While I was competent, I remained the sole lifetime beneficiary of the revocable trust. The money was mine for my care, housing, gifts, taxes, and ordinary life. No child owned a current share merely because an old schedule named a future remainder. Linda had originally been a contingent beneficiary of one family branch. That meant she might receive property after my death if the trust remained unchanged. It did not mean that half the money was already hers, and it gave her no right to move $4.1 million while I was alive. After the court confirmed my capacity, I met Priya alone, consulted a second independent attorney, and completed another capacity certificate on the day I amended the trust. Daniel was not in the room. He did not become trustee, trust protector, financial agent, or account signer. The corporate trustee would remain in control of administration. Under the amendment, Daniel would receive my house after my death and become the lifetime beneficiary of a $5 million support trust. Northbridge could pay for his health, housing, and ordinary needs. He could not redirect the principal to himself or decide anyone else's inheritance. I did not give him that share because he made one motel trip. I gave it because for 3 years after Rachel died, he kept showing up when there was nothing to gain. Because he challenged my lie instead of flattering me. And because, even after learning the balance, he refused access and asked me not to reward him during the case. Sophie's branch remained protected in a separate trust. It would pay for education, health, a first home, and later staged distributions under an independent trustee. Daniel could advise her as a father, but he could not withdraw her money. The balance remaining after those defined gifts would go to a foundation providing lawyers and emergency housing for older people targeted through financial abuse. Linda would receive no direct distribution and no control position from my trust. I did not take her house, her retirement account, or property she already legally owned. I changed only the future disposition of assets that were still mine. The criminal court handled the crime. The trust handled my choices. I refused to confuse the two. Sophie asked whether removing her mother would also remove her. No, I told her. You are not an extension of Linda's conduct. That answer protected more than money. It kept punishment from spilling into the next generation. When all documents were signed, Priya sent each affected adult a plain language summary through counsel. There would be no hidden final sentence at a theatrical will reading. Daniel learned what he would receive while I was alive and immediately asked whether the support trust could be reduced. $5 million is too much. It is not a medal, I said. It is a plan. Then promise me Sophie comes first. Her trust is already funded by formula. Yours cannot reduce it. He read the summary again. And I cannot manage yours while you are alive. You cannot manage it after I am dead either. Northbridge does. Good. That one word reassured me more than gratitude would have. Linda wrote once from the county facility before her release. The letter did not ask forgiveness. It said I had humiliated her by playing the recording in public and stolen what Ruth intended for her. I answered with 4 sentences. Ruth never intended for any child to declare me incompetent with an altered medical letter. The recording was evidence in a hearing Linda initiated. My debt test was wrong, and I was sorry for that harm. If she ever wanted a relationship that did not begin with a balance sheet, I would listen under the conditions set by the court. She did not reply. Karma is a word people use when a greedy person loses money. What happened to Linda was more exact than karma. The trustee stopped a transfer because the documents failed review. A probate judge rejected control because the evidence did not support incapacity. Investigators built a separate criminal case from preserved records, and I changed my own revocable trust only after neutral professionals confirmed that I understood the decision. No one lost $41 million in an account for 8 years. No son-in-law became rich because a judge liked him. No daughter was arrested merely for leaving her father at a motel. Linda faced formal consequences because she directed a copied signature, an altered medical letter, and an attempted $4.1 million transfer. Daniel remained family because he behaved like family before he knew there was anything to inherit. On the first cold Sunday after the case ended, he arrived at my house carrying Ruth's green thermos. He had sanded the rust from the bottom without touching the dents. The old silver scars still showed through the green paint. Rachel said her mother, "Never let this thing go empty," he said. He filled it with coffee and set 2 ordinary cups on the porch table. There were no lawyers, account statements, or sealed envelopes between us. I poured his cup first. "Are you testing me again?" he asked. "No, good. I brought pie." We sat where the new porch rail caught the morning light. Somewhere in Priya's office, the amended trust named every beneficiary and every limit in language no one needed to guess about. On my porch, Daniel asked only whether I wanted the last slice. The coffee was warm. The papers were somewhere else. That was how I knew which one of us had come home for me.